Okay, this is a live interview session with the IPOB lead counsel, Ifeanyi Ejiofor Esquire. He will be here with us and as well brief us regarding today's court proceedings of the federal government of Nigeria versus Nnamdi Kanu, leader of IPOB, the indigenous people of Biafra. So we are here to hear from the lead counsel of IPOB. Barrister Ifeanyi Ejiofor, please go ahead. Tell us what transpired in court today and as well what we would have to look up to subsequently.
Thank you so much, my brother. Actually today
1649.
is bogus, frivolous, and unsustainable. It's also laughable in the sense that the proof evidence they are relying upon was the same document which the court ruled upon in 2017 during the period we challenged 11 count charge they filed against our client and 4 others, which is extrajudicial statement made by a proposed witness to the prosecution. In that ruling, the court struck out 8 counts out of 11 count charge and made a remark which is contained in the ruling delivered by the court on that previous objection, that even the proof evidence attached to this charge cannot sustain the charge. But since the prosecutor said they had witnesses elsewhere to call, she can bring them. So that's the same proof evidence which the prosecution is relying upon today in further amendment they carried out in 2022. So, and that proof evidence cannot sustain the amended 50 count charge. Fundamentally, there's no place in the 14 count out of 15 count charge where it was disclosed that our client committed an offense at the point where the venue of the offense allegedly committed was disclosed. Secondly, in compounding their case, there was no place in that 14 count charge where it was disclosed where the information, the alleged information constitutes an incitement or whatever they call it, was received in Nigeria. There's no place it was disclosed in the charge they filed. However, furthermore, we've challenged the extraordinary rendition of our client who was abducted in Kenya on June 26, 2021, and consequently extraordinary rendition to Nigeria. This fact was exhaustively discussed. The facts of this extraordinary rendition was discussed in our objection. This is a very fundamental issue that we deny the court the jurisdiction to proceed with this case because the system was not allowed to benefit from their own wrong. The fact, the manner in which our client was abducted in Kenya without following the due process, without taking advantage of extradition proceedings, legally recognized under international instruments and conventions, before being brought to Nigeria, it's not an issue that we treated with levity. And unfortunately, the federal government never responded to any of those allegations. They never clarified as to where he was abducted, even in their account affidavits. never mention of any facts as to a rebuttal of our allegations about.
It's 1653.
Our application and consequently discharge and acquit our client who has committed no offense unto law. Because we also of the view, going by what we have before the court today, that the pro-evidence attached to the charge, which is the lifeline, which gives the charge life, is not sufficient enough to warrant the calling of our client to enter the witness box established.
It's 1654.
That we observe, I wish the court have been invited to look into. So, of course, during the proceedings, you hear the court mention the fact that we raise several jurisdictional issues that will take our time to look into and address squarely. So, and if the court will find our application meritorious on the 8th of April 2022, the court will strike out the charge our client and acquit him. Then we'll go home with him. And we're hoping that that will happen on 8th of April 2022. Thank you.
Okay, thank you very much. During the justice ruling for today, she made mention of returning leaders' wares, those that were denied of him during the last visitation. Although he made a comment, the justice made a comment concerning the preference of clothing. So we would want you to enlighten more on that, please.
Before now, the court made another history. His clothing should be changed before today. We personally visited since after the last adjourned date. At least three occasions I witnessed the new clothes they were brought for him to change. But DSS never mentioned anything to me. He never told me about the reason why they're rejecting the clothes. Until today, we had it from them in court. I made strenuous efforts to reach the director of Lego at last visit. That was last week Thursday. I was there, and eventually I spoke with him afterwards. He told me that they're going to reach. You want to discuss with the other people involved, other senior officers in the establishment, to take a decision one way or the other. But today in open court, they said it openly that they actually their practice won't allow a certain clothes with a preferred motive, that they want a plain clothes. So which we didn't want to drag far, because our intention is we're not in court for any form of drama. We're in court to ensure that our client is released unconditionally. So we don't want to play into the hands or play into their pranks that will automatically lead to the delay of this case. So we decided to go on with the trial, with the hearing, with the application today. But hopefully between tomorrow and Monday, we comply with the directive given by the court to get plain clothes for him. And so I would prefer us getting a clothes for him rather than for them to sew the clothes for him. So that was resolved today, and the court made this an order. So, and our client is delighted that we change his clothes soon.
That's okay. Once upon a time, the trial justice Bintanyako had ordered that the defendant, Nnamdi Kanu, should be allowed to see his doctor, should be allowed, a comfortable room, which is free from bugs, which is free, or should I say, which is at least homely, regarding the fact that the health issue of Mazi Nnamdi Kanu begun to deteriorate. Upon a time, we have overheard that he developed ulcer. So what do you have to tell us about that? Has there been any improvement based on that, on the fundamental human right?
There are kind of some element of compliance with the directive given by court, which is called court order. So, of course, you witnessed our last 100 date that DSS reported about getting new mattresses for him, pillows and all whatnot. So to ensure some level of compliance with court order, because you know they are eventually known for flouting court orders. So they've not actually allowed his medical expert to visit him as of today. They're insisting they are using their internal medical doctors to handle his medical challenge. So on other aspects of the infraction, we have taken it up in court today. Of course, they didn't have a potential of looking at what to file because last adjourned date, they denied access to 2 persons who were billed to see him. So they couldn't explain to me why that was so. It's part of issues that contain our affidavit far before the court today. So, however, we are making progress, and we, of course, you know, in the course of this trial, a lot of distractions will be coming in, either based on their legal strategy or based on their tactics, because they can introduce anything to derail or distract what's our approach. But we are more focused in getting our clients out, and also other infractions that has to do with his non-compliance substantially with order of court. We reported the court, and we shall file from 48 before the court, and also file affidavit in support of same. So they are all before the court. They are live today in court. So the court was more concerned, of course, you know, so you can see the court disposition and countenance. It was more concerned today on proceeding with the main application before him. So even when the learner Chief Michael Zekome, who's leading us in the matter, narrated our ordeal before this morning in the hands of the security agents, how we were delayed, how even people who are coming along with us were delayed. Nearly we have missed court proceedings today because we are trying to get clearance for them. The court actually noted them and insisted we should progress. Though towards the tail end of the proceedings, the court came back to address some of these issues, disturbing and troubling issues SN raised. So we should be focused, and we should be mindful of the fact that what we are doing in court borders on getting our client doing that kind of release unconditionally from detention. So I wouldn't want to entertain any form of distraction arising from anywhere going forward. So that has been a decision we've taken, and so God being so kind to us, we get it done. And I can assure you substantially that by 8th of April there will be uncommon victory in court on that day. Thank you.
Okay, thank you very much. Barrister, amid the 34 lines of affidavit filed by your team, I understand the matter of IPOB prescription and the level of being of a terrorist organization was mentioned. I just want you to tell us about that matter so far, because I understand as well it has been in the appellate court for a while. Is there going to be any progress anytime soon?
Thank you so much. First of all, let me clarify this. You won't say that the judiciary is not unaware of the fact or the status of the IPOB today. They are aware that there is an appeal challenging the purported prescription of IPOB, which is pending before the Court of Appeal today. That's having been said, I will fortify this fact by telling you at this point in time that since the purported prescription of IPOB in 2017 to date, not one member of IPOB has been convicted by any court on grounds that they've been prescribed. Because at any point in time that issue results in court, we always avail the court of the process to file a Court of Appeal, because this is a subject matter before the Court of Appeal, and it's not expected. Parties are expected to maintain status quo pending the court's termination of the appeal. Just like what submission of SN today, Chief Michael Zekome, that assuming that someone is convicted for belonging to IPOB, assuming someone is convicted, that's if you're taking the prescription as having been sanctioned. Then tomorrow, the Court of Appeal upon the prescription of IPOB. We'll go to the prison and bring the person back and say, please, this law has been, this prescription has been changed. The answer is no. So we have severally done it in court in Port Harcourt. I've done it, personally did it in Oka, Federal High Court, Oka, Port Harcourt, Umuahia, and name them. And the court upheld my submission to that effect, that the court cannot pronounce, cannot take further step on the charge that has to do with prescription of IPOB, because there's an appeal against that prescription. And let me inform the world today, and also by extension, everybody who cares to know, that this appeal has been scheduled for hearing, different hearing, on the 7th day of April 2022. So we had a day before the ruling on our application today. So we need your prayers also, and also your support and solidarity too. So I don't think there is anything, because IPOB has no characters of terrorist organization. Of course, the manner in which they were prescribed, obtaining a black market order at the wee hours of the night, that reference to us is indicative of the fact that due process was not followed. Because the law is very clear on the character of an organization that can be prescribed, right? So that wasn't complied with. So we have submitted our appeal, strongly led in law, and also before the Court of Appeal is coming up for hearing, definitely on 7th of April 2022. So we keep you updated as we progress. So this is why we are challenging the charge, which is count 3 of the amended 15-count charge. That is the IPOB leader and prescribed organization said no, and that was why he pleaded not guilty to the charge. And the press didn't get it correct, because the prosecution mischievously wants to mislead the public by telling the public that Nani can deny the being IPOB member. He never denied being IPOB member. What he denied, in fact, is that he is not the leader or a member of a prescribed IPOB, because as far as concerned, IPOB is a lawful organization. Don't forget that this very court, Honorable Justice Nyako's court, ruled in 2017 that IPOB is not an unlawful organization. It's a full judgment of the court to have it today, and it's having before a court appeal. He ruled in application urging the court to strike out the charge that borders on the status of IPOB. The court in ruling said that IPOB has no character of an unlawful organization, and as such, is not an unlawful organization. So that ruling stands today. It hasn't been appealed against. Are you getting me? It hasn't been appealed against. So it's a ruling of the court which has not been appealed against. So we have built our case on facts, we have built our case on law, and we have that belief that God being on our side, we are going to succeed, even in court of appeal. Thank you so much.
Thank you. Again, on the 19th of January 2022, your client, Nnamdi Kanu, was on the side of winning, or should I say won, a ruling or a case in the Abia High Court, and it is a case pertaining to fundamental human rights in the Court of Justice Benson Anya in Umuahia. One of the rulings says that the federal government and the Nigerian army, the duo, should render an apology to Nnamdi Kanu. Another says that Nnamdi Kanu be compensated to a tune of R1 billion owing to what happened in his home state on the 14th of September 2017. So we want to know hitherto what has happened so far in that regard, please.
This is an order of court and a full judgment of the court, and that has been served on the federal government awaiting compliance. And federal government is not above the law. They must definitely comply with the order of the court. Otherwise, certain steps will be taken to ensure compliance. That action was initiated by my colleague, Ejiofor. So, and the court delivered judgment on the merit, and it hasn't been appealed against. So, as of today, the federal government is still incompetent of the court's judgment orders, because these are the final orders of the court which they must obey. And I believe steps are being taken to ensure compliance, which I may not be, which may not be public here. Are you with me? So steps are being taken to ensure compliance with with those directives from the court. It's a full judgment of the court. So thank you.
Okay, finally, what do you have to tell the teeming populace of your clients in this regard and what has happened so far and what is to come?
Okay, what I can tell Umuchineka at this point in time, Oyendumazun and the counselors, people of good conscience, people who are still loyal to him, people who are still resolute and not distracted. It's for them to remain resolute and not distracted. At this point in time, a lot will be happening. To ensure people are being derailed. A lot will be happening to ensure that narrative is changed. But I can assure them that victory is ours. Take it to the bank. That I can assure them. They should remain focused and believe that in no distant time, Mazi Nnamdi Kanu will be freed. And people will see him live and direct. We are not leaving any stone unturned to ensure that happens. No matter, there's no amount of distraction, blackmail of conspiracy of any kind that will make us to lose focus. Of course, I'm more determined than anybody. So, of course, except a person who has skeleton in his cupboard will be afraid of any form of distraction. I'm not perturbed. I'm not afraid of anybody. Once I know I am on the side of law, and I urge them to remain peaceful, prayerful, resolute, and also to understand when distractors are coming. Understand when people who are paid to distract them are coming, because this is a very critical time. People should advise themselves. This is a very critical time. People should make use of their number 6. This is a very critical time. People should look very well before they leave. This is a very critical time. People should listen with both ears. So that would be my kind advice to them. And I can assure them 100% that Mazi Nnamdi Kanu will be released soon. I am hopeful. We are hopeful. We in the legal team are hopeful that sooner than later, Nnamdi Kanu will regain his freedom. And those who have been derailed, we give account of their stewardship. Thank you so much, and God bless.
Okay, thank you very much. That was the voice of the IPOB lead counsel, Ifeanyi Ejiofor Esquire, talking to the Biafra Times correspondent, Chikwas Onwikbe, via the Biafra televisions. And the next adjourned date, as he did put forward, remains on the 8th of April. Thank you very much for joining us.
Thank you.